The Honourable Susan Carter.
Thank you, Madam Assistant President. I rise on behalf of the opposition in relation to the Electoral Legislation Amendment Elections Bill of 2026, and I join with the Minister in adding our thanks to the work of the Joint Standing Committee. And I also note there's been quite a degree of constructive discussion between the Shadow Minister in the other place and Minister Graham with regard to these reforms, and a high degree of consensus has been reached with regard to the provisions. Indeed, it's essential that a number of matters be resolved in the lead up to the 2027 State General election, especially the date, because without changes, the general election would occur during the Easter period next year, which is undesirable and inappropriate for a number of reasons. Therefore, it's necessary to bring the date of the election forward by 2 weeks. We are advised, and I believe the Minister said in the second reading speech, that the caretaker period for the government will now commence on the 19th of February 2027, and the regulated period under the legislation will commence on the 22nd of February 2027. There are a number of fairly uncontroversial changes arising out of joint positions with regard to the Joint Standing Committee on Electoral Matters, but there are some matters that I would particularly like to highlight. The first is found in Schedule 1, paragraph 92, which makes important changes to the rules around postal voting within our state. There is a prohibition under the proposed new section 219 A, whereby 1. A person other than the Electoral Commissioner must not distribute or cause to be distributed an application to vote by post in an election unless A. the application is in the form approved by the Electoral Commission, and B. the form states that the application must be submitted directly to the Electoral Commissioner, and C. no additional information or matter appears on the application. 2. It is not an offence for a person to make available at a post office an application to vote by post provided by the Electoral Commissioner. However, proposed new section 219 B contains the following prohibitions. 1. A person must not solicit another person to return or submit the other person's application to vote by post to anyone other than the Electoral Commissioner. And 2. A person other than the Electoral Commissioner must not, in connection with the distribution or collection of another person's application to vote by post, collect personal information about the other person without the other person's written consent. The upshot of these new rules is that candidates may distribute postal vote applications in compliance with sections 219A and 219B, but they must not solicit a completed postal vote application to be returned to themselves or any third party. And they must ensure that the direction is to return that postal vote application to the Electoral Commissioner. A number of other changes to postal voting relate to forms and how postal votes are counted, and so on. Part 6 in Schedule 1 at paragraph 99 to the bill allows the Electoral Commissioner to switch on or switch off certain provisions with regard to postal votes at by-elections on 60 days' notice. I understand that there may be some logistical matters that relate to by-elections in particular, and on the advice of the Electoral Commissioner, that makes it desirable for the Electoral Commissioner's ability to switch on, switch off provisions because of logistical matters which arise relating to the urgency of by-elections. One of the effects of the new provisions with regard to disclosures on electoral matters is that the previous requirement for the printer of electoral material to appear on electoral material has been taken away. There is still a requirement that the details of the person who has authorised the printing, publishing or distribution of electoral material is to be disclosed on the material. The detail of the printer, which often was logistically difficult and required pedantic changes for no real benefit, has been taken away. That is a welcome change due to the practical necessities of creating printed material at election time. A number of new provisions within the bill distinguish between registered political parties and independent candidates, including not allowing the term independent within a registered political party's name. Other provisions deal with funding that is different between political parties and independent candidates. These are appropriate measures because independent candidates, without a registered party around them, operate in a different fashion to registered political parties. Independent candidates should not seek to both approbate and reprobate, on the one hand taking advantage of being an independent, but then not taking on some of the burdens of being a political party. These matters distinguishing between independents on the one hand and registered political parties on the other need to be philosophically and ideologically consistent throughout the legislation. There are new provisions with regard to registration of electoral material as it relates to early voting. Early voting electoral material must now be registered if it is to be distributed within 100 metres of an early voting centre. That has required new provisions which I think will be further amended by the government with regard to the registration of electoral material during the early voting period, which will be a week before the general election. I wish to turn in a bit more detail to some important new provisions with regard to material produced by artificial intelligence. Schedule 1 at paragraph 81 concerns proposed new sections 189 capital A and section 189 capital B. New section 189 capital A would state 1. A person must not, during the regulated period, print, publish, distribute or publicly display digitally generated electoral material that contains a depiction of a simulated person performing an act that the real person depicted in the depiction did not perform. The bill outlines the various penalties that will apply to somebody who breaches that provision. The bill provides that digitally generated electoral material for the purposes of this provision includes A. Electoral material containing audio-visual, visual or audio content that is generated substantially or modified or altered significantly by artificial intelligence, but B. does not include a cartoon or animated drawing. I'm sure from time to time that members have seen on social media quite realistic depictions of people performing acts which they did not do, as some depictions on social media, presumably made using artificial intelligence, might represent. We see it all the time, for example, in documentaries about historical events. There will be material created by artificial intelligence or by actors doing a recreation that can convey entirely truthful and reliable matters. Were those materials produced by artificial intelligence, that should not prevent them being used in an election campaign if the content of the material is true or relates to a matter of fair comment. For example, if a government were to shut a school, a piece of audio-visual material might show the leader of the government or an education minister putting a padlock on the school gate as a metaphor for the fact that they have shut the school. This provision in the bill would make that material illegal. It would have a chilling effect on the freedom of political expression, even though it is entirely 100% correct and factually true, given that politics is frequently the subject of metaphor. I'm sure we all realise that environmentalists in koala suits are not actually koalas. Metaphor is common in political debate, protest and political expression. I cannot possibly see how a provision of this kind would ever survive a constitutional challenge, having regard to the doctrine of the implied right to freedom of political expression that the High Court has developed in the Australian Constitution. I invite members to read judgments from the original Australian Capital Television decision from the early 1990s through to Lang and Australian Broadcasting Corporation, Theophanous and a number of other cases. The High Court has said that to even require material to be truthful unfairly burdens the implied constitutional right to freedom of political expression, and therefore reasonableness in publication of false facts should be allowed. The provisions as drafted are not in conformity with the freedom of political expression in our country, which centres around a system of responsible government, as the High Court has found. To make things worse, the restriction on the freedom of political expression will occur in the regulated period closest to an election when people are most engaged in how they exercise their democratic choice. The restrictions will commence on the 22nd of February next year, during the most crucial weeks prior to the state election. They will preclude people from producing, disseminating and distributing true material that is reflective of things that have actually happened. I use the example of putting a lock on the gate as a metaphor for the closure of a school. Not only is it a constraint on the freedom of expression, but it will also have a chilling effect on people determining whether a metaphor is within or outside of the legislation. Could I be prosecuted criminally for making this political point in the context of a state election or by-election? Obviously, the opposition is concerned about this, because these well-intentioned protections could be struck down by the High Court, leaving there no protections against false AI-generated material. It is important to also understand that these provisions with regard to AI-generated electoral material in the bill are not the product of any evidence before a parliamentary committee, but entirely the creation of the government. Just as there is in the law of defamation, which is another curb on the exercise of freedom of expression, as Lang and Australian Broadcasting Corporation made clear, we propose at the very least a defence of truth or fair comment for these provisions. That would at least enable robust campaigning, which the constitutional implied right makes clear is part of our system of democratic government. Similar problems occur with regard to new section 189B of the Act. The new section 189A creates a complete prohibition on AI-generated truthful material with very limited defences. The only existing defence is one of consent. In a political context, it is unrealistic to think that one's political opponent would consent to material that may be a metaphor for their actions. The consent defence would only assist advertising favourable to a political party and not unfavourable advertising, completely misunderstanding the conflict of ideas and policies at the heart of a democracy. An alternative defence is that the defendant took no part effectively in producing the content. They are the only two defences. There is no defence of truth, no defence of fair comment, no defence of reasonableness, and no defence of publication on a matter of public interest, which all appear in the Defamation Act as is currently the law of this state. Truth and fair comment have been defences against defamation suits under our law for several hundreds of years. Those defences are thought to rightly balance an incursion on freedom of expression by a civil defamation suit against the right to say or publish true material or material that is fair comment. The amendments made by the government in the other place to those sections do not deal with these problems. New section 189B, as drafted in the bill, makes it an offence during the regulated period for a person to print, publish, distribute or publicly display digitally generated electoral material unless it contains a statement that is digitally generated electoral material. The problem with that section and with the government's proposed amendment to that section is, again, that digitally generated electoral material may be entirely true. It may include a graph with statistics from the ABS showing inflation over time. It may be AI-generated persons, events or places that are entirely accurate. And yet, in the public's imagination, the requirement that there be a disclaimer that the material has been digitally generated causes a doubt in the public's mind as to the veracity, the truthfulness and the integrity of that material. Although AI-generated material can certainly be wrong, and artificial intelligence, as we know, hallucinates, it can also be material that is 100% correct from reliable sources. The idea that a candidate, because they have used AI to produce true material, would have to impeach their own material by a statement of the kind contemplated by new section 189B, or if they do not, then they will commit a criminal offence, is a huge incursion upon freedom of expression and freedom of political expression, and will have a chilling effect on the sort of robust discourse not only that a democracy encourages, but also that the High Court has said is essential to representative democracy. New section 189B relates to the regulated period. Again, it is in that crucial period, right before people are about to vote, that there is this restraint upon the freedom of political expression. I am not defending false electoral material. I am not protecting unfair comment. Fair comment and proper material for comment has to be substantially true or based upon a protected report or based upon other material that is proper material for comment. There are already restrictions on what a fair comment can be. Section 31 Subsection 5 of the Defamation Act says that an opinion is based on proper material if the material on which it is based is set out in specific or general terms in the published matter, or notorious or accessible from a reference link or other access point included in the matter, for example, a hyperlink on a web page. That is how Section 31 of the Defamation Act defines proper material for comment. This bill should include provisions of that kind as a defence so that people can produce truthful material, they can publish content based on proper material for comment, and therefore the burden on the freedom of political expression is proportionate and reasonable, and not absolute as this bill is currently drafted, regardless of whether the material is true or is proper material for comment. Another matter of concern, which I believe is now resolved, is the matter of Section 268, subsection 1 of the Electoral Act. This provision has an interesting history, which I have tracked in the past and will summarise briefly. What occurred was as follows. The regime of elections in New South Wales prior to the Electoral Act of 2017 and the Electoral Funding Act of 2018 was governed by the Parliamentary Electorates and Elections Act of 1912 and the Election Funding, Expenditure and Disclosures Act of 1981. Prior to the enactment of Section 268 of the Electoral Act of 2017, there was no prohibition on the Electoral Commission or the Electoral Commissioner from making disclosures with regard to investigations into possible contraventions of those pieces of legislation. Section 268 of the Electoral Act of 2017 introduced for the first time a restriction on the Electoral Commission or the Electoral Commissioner such that they were only able to disclose matters of that kind if it was in the public interest and other provisions applied. There was an allowance for the reporting of previous transgressions, but the allowance did not include transgressions under the Parliamentary Electorates and Elections Act of 1912 or the Election Funding, Expenditure and Disclosures Act of 1981, because there was no prohibition at that time on the Electoral Commission or the Electoral Commissioner from making such disclosures. It has since arisen that the Electoral Commission and Commissioner have taken the view that they are precluded by Section 268 from making disclosures of information under previous legislation, even though they are not referred to, nor does the exception apply to them. This bill seeks to make amendments to Section 268, which, by Schedule 1 at 98, will enable disclosure in the public interest of prior matters. In the transitional provisions, which appear as Schedule 1 at 99, New Part 7, Clause 5, under the heading Disclosure of Information in relation to contraventions under former acts, which sought to originally limit the permission for the Electoral Commission to disclose matters that have occurred, investigations that have taken place, and findings that have been made under the previous legislation, applied only to investigations, regulatory action or compliance audits that have not been completed before the commencement of that provision. That means historical matters that have previously not been disclosed to the public because of the view taken by the Electoral Commission and the Electoral Commissioner would not have been free to be disclosed under that provision. Transparency in government with regard to electoral matters and investigations surely required that the absence of a retrospective provision be taken out of this bill. Pressure from the Coalition, recognising an attempted improper provision in the bill to be retrospective, as they should have been. It is the right thing to do. I do not think this Parliament would support a cover-up of the kind contemplated by a provision of that type in the legislation. The government brought forward in the other place a number of issues as a consequence of our discussions. They deal with tweaks and refinements that relate to the new provisions regarding electoral material being required to be registered for early voting. We have had some feedback and fruitful discussions in relation to that. The government, mostly at our instigation, have made amendments in the other place that will improve the bill. The rules around general elections and by-elections that are covered within the bill are matters of great importance to our democracy and to the fair exercise of the people's vote within our country. We are fortunate, both federally and at the state level, to have electoral commissions that are independent bodies that regulate the operation of our democratic elections. Other countries that people might think are like ours, such as the United States, do not have such independent bodies governing their elections. The rules are different from state to state in the United States and are administered differently from state to state. Indeed, the concept of the gerrymander commenced in America because Congress determines the boundaries of electoral districts, and a considerable amount of deal-making goes on that benefits the incumbents. We are blessed to have a democracy that operates elections as well as it does. The major area of disagreement between the opposition and the government in respect of the bill concerns the exercise of freedom of speech on matters that are true and fair comment. Those very important values are recognised by the High Court and have given rise to the implied right of freedom of political communication within our democracy. Those matters are important, and we will move amendments to ensure that this legislation does not transgress those important principles.